This module reviews some of the key points in special education law related to positive behavior supports. In this module, I will provide a lot of technical information, so I want to remind you to view this video in a quiet place multiple times and referring to the script that is available by clicking the script tab on the left if needed. The 2004 reauthorization of the Individuals with Disabilities Education Improvement Act, which we usually refer to more simply as IDEA, is the law that describes federal and state responsibilities in educating students with disabilities. IDEA is a civil rights law. It protects the rights of students with disabilities to a free and appropriate public education in the least restrictive environment. Functional Behavioral Assessment, FBA, and Positive Behavioral Interventions and Supports were added to the law in 1997 in recognition that some students have behavior problems related to their disabilities that jeopardize their participation in education. And these are the only strategies related to behavior that are specifically mentioned in IDEA, with a specific reference made to the evidence supporting their use in preventing exclusion and improving educational outcomes. There are times the law says that positive behavioral interventions and supports must be considered, and other times that a functional behavioral assessment must be provided. IDEA requires schools to consider the use of positive behavioral intervention and supports for any student whose behavior interferes with the child's learning or the learning of other children. This consideration may take the form of an FBA and behavior intervention plan. There are also circumstances when FBAs must be provided according to IDEA. The first of these is when a child with a disability is removed from more than 10 school days or behavior that relates to the child's disability. Note that these 10 days are cumulative, so that 10 single day suspensions for similar behaviors would trigger the FBA requirement. Clearly, if a student misses 10 days of school, that child is missing a big part of their education. If a child with a disability has been ordered to be removed long-term because of their behavior, the school must hold a meeting called a manifestation determination review to determine if the behavior is related to the child's disability or if the misconduct was the direct result of the school's failure to implement the IEP. This must occur within 10 school days after a disciplinary action involving removal for more than 10 days. The outcome of the manifestation determination review guides the FBA process. If it is determined that the behavior is caused by the child's disability, an FBA must be conducted if it was not done so previously. If the behavior is determined to not be a manifestation of the child's disability, an FBA may be conducted as appropriate. If the student's misconduct involves weapons, drugs, or serious bodily injury, an FBA may be conducted as appropriate. Remember, there is legal support for FBAs and behavior intervention plans in schools. If you are an educator, do not hesitate to recommend an FBA. If you're a parent, do not hesitate to ask for an FBA to be completed. Parental consent is required prior to a school conducting an FBA on a child. Finally, if a school conducts an FBA that you as a parent feel is not representative of your child's behavior or is not as thorough as you would like, you have the right in many circumstances to request an independent FBA be conducted at the school's expense. This segment provided a brief overview of the legal requirements related to FBAs and behavior intervention plans. In the next segment, we'll talk about the importance of families and schools working together on a student's individualized education program, or IEP, especially when behaviors are a concern.